Hello, this is a meeting of the legal non-conforming land use decision appeal hearing for Wednesday, May 31st, 2023. And I will call the meeting to order. We have two councillors missing, Brenda Rowe and Councillor Inkster. And so we're going to proceed in any event. Pursuant to Section 60 of the Community Charter, as well as District of Sechelt Business License Bylaw number 520, 2012, I now call the legal non-conforming land use decision appeal hearing to order. Are there any conflicts of interest? Please go ahead.
Thank you, Chair. I'd just like two things. First of all, Councillor Rowe, is we both had a conflict and we sort of flipped a coin and she got to go to the other meeting and that's why she's not here. The other thing I wanted to make clear, and some have implied that I might have a conflict of interest in this matter, and I've considered it carefully, and I want council to know that I believe the matters at hand are no different than anything that we've discussed about the short-term rentals over the last some months. So I did not have a conflict then. I'm confident I do not have one now. And I intend to fully participate and make decisions in the best interests of Sechelt in accordance with my oath of office. So thank you.
Thank you. I'd like to welcome you to this hearing regarding the recent non-conforming land use decisions. In 2023, district staff received applications from property owners wishing to have their properties designated as legally non-conforming to zoning bylaw 25, 1986. Since then, staff approved 22 properties as legally non-conforming and denied 12 applications. Today, council is holding a hearing to consider appeals from various property owners and operators of short-term rentals that were not granted lawful non-conforming status from staff review, hereafter and called the appellants. We've received staff reports on the factors that were considered in denying the request for legal non-conforming use status and information provided by the appellants. Today, the appellants will have the opportunity to present their case to this council and explain why they believe their property should be declared legal non-conforming use. Council may ask questions of staff or the appellants for clarification if required. During this hearing, we will only consider specific cases at hand, which are the reasons cited for the denial of legal non-conforming use status. We therefore request that all the appellants inform us of the reasons why they consider their property to be legally non-conforming and not refer to other aspects of their property or operation. We understand the importance of providing appellants of an adequate opportunity to express their concerns and present their case. 10 minutes have been scheduled for each appellant. On this, I note that all of us have carefully reviewed the documents you've provided. We urge all appellants to provide clear and concise statements so as to enable us to have a thorough understanding of your position within the designated time frame. We value an open and fair dialogue, and we council members are here today to carefully consider your arguments. Thank you for your attention, and we look forward to hearing your perspectives as we proceed with the appeal hearing. At this time, I invite staff to outline their decision-making process with respect to their assessment of applications for legal non-conforming land use. Following this presentation, we will then consider each application. Staff will provide a brief summary of the specific factors applicable to each of the applications, and the appellants will then be invited to present their evidence in the order listed on our agenda. Following this, we will render our decision based on a majority of vote of those in attendance at this hearing. Thank you. Turn it over to Dr. Allen.
Sure. Thank you, Chair. I'll be brief. So in terms of our process, this was endorsed by council earlier this year, and we reached out to all known short-term rental operators of within the type 3 category offered the ability to apply or seek status as lawful non-conforming. And we received several applications, I believe 34 requests. In some cases, we responded to folks seeking further information, clarifying the process, seeking affidavits of certifying information to be accurate, and so forth. Mr. Hall here, as the development planning manager, led a review team that included our community planner and our planning technician, as well as our building official, and looked at each of them and presented to me their findings. In many cases, I simply had the civic address and a summary of their findings and agreed or did not agree. In the odd case where I did not agree, I pushed back to seek more information, more clarity, and to come back to me again. And we tried to do this as fairly and objectively as possible. So we're down to 12, and I believe there are 7 on the agenda today. So not everybody who was offered the ability to attend here took us up on that opportunity. And so we reviewed each of them. We provided a brief summary here attached. We've also attached information that each of the appellants gave to us. We reviewed this, consulted with our solicitor along the way to ensure that we took the correct approach and fair, reasonable, and consistent approach throughout. Primarily, we identified 3 areas where we thought nonconformity to our now repealed zoning bylaw could not be confirmed. The first one was the presence of a second suite. Zoning bylaw 1987 indicated that a dwelling, any dwelling could have a suite, but either the primary dwelling unit or the suite must be occupied by the owner of the dwelling. So in some cases, 2 suites were rented out for short-term rental, or it was not clear that the owner was in fact living in that suite. The second one was parking. The short-term rental regulations required on-site parking as an off-street, and sometimes acknowledging that that boundary is a little less clear and road allowance might be wide in front of a property. But there are cases where there was no parking on the property itself, which was a zoning requirement dating back to the now repealed zoning bylaw. And the third one, more limited, but along that lines, was a dwelling that was confirmed to be so old that it was not located in the district of Sechelt at that time, and before the district expanded in the 1980s, and also so old that there were likely no building permits and or zoning bylaws at the time. So parking for the dwelling itself never did require, or the zoning or any of the rules never did apply to parking on that site. However, our short-term residential regulations were brought in 2006, which would have required parking for short-term rental. So while one could argue the dwelling does not require parking, the use contained within the dwelling would. So that was our third category. So the 3 categories that we reviewed this through, leading to the 12 that we did not approve, and leading to the agenda today. And so each one of them slightly different, as a covering memo prepared by Mr. Hall. And he will do his best to answer any specifics on those questions, and I can help out where need be. Thank you.
Thank you. Then we'll start with the first item on the agenda, which is 4851 Sunshine Coast Highway.
Thank you, Council. So for 4851 Sunshine Coast Highway, in looking at this application, the primary reason for the denial was the presence of a secondary suite. And, we kind of detailed in the memo all the things we were looking at, but this is a case where the secondary suite was the rationale for the denial. And as Director Allen mentioned, in zoning bylaw 25, the regulations state that where there's a secondary suite in the house, that the owner must be resident on the property, which would prohibit the type 3 unhosted short-term rental.
Okay, thank you. I wonder if the appellant would like to speak to this item.
Thank you. Good afternoon, councilors. My name is Greg Bellamy. This is my wife, Sandy. Thanks for the opportunity to present new information here to council, demonstrating we were compliant with the previous bylaw. We own a 2-dwelling house at 4851 Sunshine Coast Highway. The main floor, which we call the Vista Suite, is a short-term rental. We also have a garden level suite. We're applying for lawful non-conforming use recognition for the Vista Suite only. It was 100% lawful. We're not applying for the garden suite, and the garden suite isn't in operation. Lawful non-conforming use is a statutory protection the province provides. It's a legal right granted to each lawful use of a property when bylaws change. We're asserting our right to continue to use this main living space of the house in the same legal manner we did before the new bylaw was changed. The previous zoning bylaw for our property allows single-family dwelling, short-term rentals, and secondary suites. Each has permitted uses. It's clear that properties can have more than one legal use at the same time. You might think of this like an apartment building with a restaurant on the first floor, offices on the second floor, and residences above. An unlawful use of any one space does not make the other spaces unlawful. Planning has suggested that the Vista Suite is unlawful simply because of the existence of a secondary suite. This isn't consistent with the case law and certainly not with common sense. There were 2 different uses in 2 different dwelling units on the property. It's clear at law that the non-legal use in one part of the building does not make the other part unlawful. Each use should stand on its own. That's the law. Here's the wording of the BC non-conforming use authorization law. Subject to the section, if at the time a land use regulation is adopted, land or building structure to which that bylaw applies is lawfully used, and the use does not conform to the new bylaw, the use may be continued as a non-conforming use. Law really is that simple. Lawful uses are protected from bylaw changes. It's a fundamental right, and it's pretty consistent across Canada. With the application of good legal advice, we've clearly proven that our Vista Suite was 100% lawful use, with no allegations that it was not. Ian Hall of Planning, when we met, confirmed that there were no issues with the suite whatsoever, legally or in any other way, except the presence of secondary suite elsewhere on the property. We ask that you follow the law and recognize the fully legal Vista Suite as lawful non-conforming use. Again, we are not applying for the other suite. We think it's a misapplication of the law to use a newly discovered bylaw infraction from a different use on the property to deny our legal right to lawful use of a fully lawful use suite. Thank you. We do, of course, I'm glad to hear that you've read the legal brief. I think that explains a lot of what we were saying. We're unaware of any information coming from the district or the legal review has occurred or what the findings of those things were. We have our lawyer on the phone. We'd love to have her speak for a couple seconds, and either she or we can answer any questions that you might have on the law or anything about our plan. Thank you very much.
Thank you.
Ms. McFarlane now has the ability to be heard.
Hi, everyone. Can you hear me? Good. Okay, I see some nodding. Thanks for the opportunity to speak today, Mayor and councilors. As Mr. Bellamy mentioned, I'm legal counsel for the Bellamies. My name is Stacey McFarlane. I'm a specialized municipal lawyer with Borden Ladner Gervais. And you'll see in the materials package, there's an opinion I provided to the Bellamies about how our interpretation of the use of the property and how it complies with the lawful non-conforming requirements of the Local Government Act. There's a few things I just wanted to clarify and point out that may assist council with their consideration today of the lawful non-conforming status. The first thing I want to emphasize is the multiple uses that we're talking about with the property. This is something Mr. Bellamy referred to. So I just want to clarify that our interpretation under the law, obviously you've got your own legal advice, but is one property can have multiple uses. This is actually recognized in your new zoning bylaw. And Mr. Bellamy gave the example of one building could have, well, for example, retail on the ground floor, an office above, and a residential above that. That's 3 distinct uses that would be in a property. Under the old zoning bylaw, there were 8 permitted uses in the R1 zone, which this property was zoned. And these included a single family dwelling, which was an undefined use, short-term residential rental, and secondary suites. And so under the old zoning bylaw, this property had 4 distinct uses at the time the new bylaw was adopted. It had 1 single family dwelling use, it had 1 secondary suite use, and it had 2 short-term residential rental uses. Not as has been identified, not all of these uses were lawful, but some of the confusion seems to arise that just because one use wasn't lawful does not mean the other uses are automatically unlawful. It might be easier to think about this in the reverse, where if one use was lawful, that doesn't make the other uses lawful as well. Each use has to be considered on its own. So for any of these old uses to continue, they either need to be permitted uses under the new zoning bylaw, or they need to establish lawful non-conforming status under the Local Government Act. In the case of this property, single family dwelling, that old use under the old bylaw, is now continued as a defined single detached dwelling. So it complies with the new zoning bylaw and can continue. Because the Bellamis want to operate their short-term rental without living on site as a secondary residence, then they also have to establish that one of their 2 short-term rental uses, as was defined in the old bylaw, which permitted it in secondary residences, was lawful under the old bylaw and can continue. As I mentioned, there were 2 short-term residential uses on the property at the time, one of which was in a secondary suite, which was illegal, making that short-term rental use illegal, but one of which was in the main dwelling unit, which was the Vista Suite, and in the single-family single-family house that was on there. And that use was a lawful non-conforming use. You'll see in the package that was provided by the Bellamis how that use met all the criteria of the old zoning bylaw and therefore was lawful. I just want to speak to a couple items that were in Mr. Hall's letter. We have a slightly different understanding of the situation, just want to be clear about it. So if you look at page 4 of council's package, there is the report from Mr. Hall. And in paragraph 4, Mr. Hall identified that this house contains 2 dwelling units. And you heard Mr. Bellamy say first that it was a 2 dwelling house and lots of talks about the 2 units. But you also heard Mr. Bellamy say that actually now what it is that that second suite is not being used as a suite. This is now a single dwelling unit building as a single detached dwelling as meets the new dwelling or new requirements under the new zoning bylaw. There's no longer 2 suites on the property, and the references to the 2 different suites was really to establish the difference between all the different uses under the old bylaw and what's being proposed now under the new bylaw and for the lawful non-conforming status.
Sorry, I apologize, but I do have to interrupt because we've reached our time limit.
Okay, that's fine. I can wrap up there. I am available if council has any questions.
Okay, thank you very much. I am now going to turn it over to council to see if you have any questions. Do you have any questions of what the appellants mentioned, or the appellant's lawyer, any questions of staff on the issue? Thank you. Please don't everyone jump. Oh,
I know what it's like sitting in the chair, waiting for somebody to put their hand up. Through you, Chair, I'm wondering if staff is any of this new to staff, or are we this information that we've just heard?
No, we received a copy of Ms. McFarland's letter and had that reviewed by ourselves and our own legal counsel. So we're aware of those arguments.
I will comment that it seems to come down to an interpretation of the former bylaw and whether there were clearly 2 units and whether that was legal or illegal non-conforming. So obviously, I'm assuming both were rented out at the same time. or they were being rented out on a short-term basis.
That's correct. They were both being operated as short-term rentals simultaneously, but they were separate, completely separate uses, locked off from each other. So the lawful use of the Vista Suite is different than the unlawful use of the Garden Suite.
Sorry, say that again, please.
The Vista Suite is legal and confirmed as so by the district, and the Garden Suite, they have alleged, is not legal. But they're two separate uses.
Thank you. I will turn it back to council. Any more comments on this? What's been presented? Please, Darren.
Thank you. So I just heard earlier staff had mentioned, based on the previous question, that they received the information, the new information as in a sense, and the legal advice and the report as it sits here stands in reference to. Okay, thank you.
Since there's no further comment, I'm wondering if we could put this to a vote then. It's really coming down to an understanding of the appellant's argument or staff's opinion on the matter.
Chair, I wonder, this is something that I think we're all struggling with, but you know, that we're hearing from our staff that there's a legal advice that they've received. We're hearing from the appellant's lawyers that they've got a different interpretation. And I must confess, I'm struggling with how do we make a decision? So I don't have an answer to that, but I'm struggling with, you know, the implications that somehow, well, not the implications, but the actual statements from the two parties that, you know, this is right and that's wrong, or this is right and that's wrong. That's not by way of a question, because I'm looking for other members of the council to help me in how they're proceeding with this as well.
I mean, my view of it is that two suites were being rented, and that the former bylaw, under the former bylaw, if a short-term rental was going to be operated, the owner was to be resident living in the premises for the 9-month period, and that doesn't seem to have happened. So it seems to me they are in contravention of the former bylaw.
If we may.
Talk about.
Sorry, I just wanted to catch something because I think I heard you say short-term rental of the suite. And in fact, it's if it's being operated as a suite that the owner needs to live on site 9 months a year. I just want to make sure we're correct on the language that we're hearing. I did have one question for our staff, though, in that when we look at our zoning bylaws, it's my understanding is that zoning is a land use regulation that applies to the property as a whole, unless the property has split zoning. And I'm just looking for clarity, like all of the properties that we're looking at today are single zone properties. So the single zone land use regulations should apply, I believe. Is that a correct understanding?
Yes, none of these properties are split zone. They're all zoned under a single zone under bylaw 25 at the time. So, you know, the short-term residential rental use was a permitted use in the residential zones, and that was the same for all of the properties at that time, whether they were R1 or R2 or R3, whatever it was at the time. And the secondary suite regulations, you know, from our interpretation says if there's a suite on the property, regardless of how it's being used, there's a suite in the house, then the owner must be resident, either in the suite or in the house. That's the basis for our decision there.
Is there any other comments on? All right, then I'm going to raise a motion that the legal non-conforming land use for 4851 be denied due to considerations provided by staff for the denial of legal non-conforming land use status, included on the appeal hearing agenda. Seconded. Any other discussion, comment on? Then I will put it to a vote. All those in favor? Thank you.
You're welcome. Thank you very much.
If we could then move on to 7471 Sechelt Inlet Road and staff summary. Thank you.
Chair Shepherd, if might just interject, we've had some comment from our online viewership that it's difficult to hear some of the speakers. So I'd just like to remind everybody to speak directly into your microphone so that you can be heard online.
For 7471, this is another case where the decision was based around the presence of a secondary suite on the property. And that was the rationale for the denial of the non-conforming use application.
Thank you. Mrs. Emmons, please go ahead.
Thank you, and thank you for the opportunity to approach this. The reason for our appeal is that there is no secondary suite on the property. It has never existed as a secondary suite. So we've got a lot of confusion over this. I think there are possibilities of where the assumption for that came from. We did ask for inspection, but we're not contacted to confirm that. Under the bylaw, the definitions are our basement would be deemed as a sleeping unit. There are no cooking facilities in the basement. There is no oven, no range, no cooktop, no hot plate. There's no ventilation capability other than what was originally built, and it was inspected as a single family dwelling. There was no secondary suite there, and there is no possibility for us to even put in a second suite. There's also no electrical down the floor. So we're not really sure where this came from in terms of, it was a surprise that we have a secondary suite. It can't be considered a secondary suite because there's no single real estate entity, which is what the bylaw states. The heat is controlled on the main floor. The kitchen is on the main floor, and our electrical and our storage is in the basement. The house has always been intended and always being used as only one family unit. And there's only one set of cooking facilities. Where the sources of confusion may have come from is that we did have a property manager who resided on the property in the house, in the situation similar to the type 1 that has been recommended currently. They had use of the entire house. There's a one-way lock at the basement door, and that is the only door that would be to their sleeping unit and where we also store all of our personal family stuff, where we store our boats. We don't have a garage on the property. We have no other place to store it. So that we needed some way that we could close off possible access guests who would be coming in. But I don't think that's an unreasonable thing, and it certainly doesn't create a secondary suite. Essentially, our property manager acted kind of in the same way as a house sitter. We're a family friend. We all had access to the whole house when we were there and they were there at the same time. When guests would stay, it was a little bit problematic because our property manager would have to either eat out or use the barbecue outside. They didn't. There was no way that we could put in a kitchen facility. That possibility was explored by us when the zoning changed. We looked at that because part of our consideration is, we would eventually like to be out here full time and run the B&B, and we would like to have that as a possibility. We determined it as a possibility. It's not possible to convert the space to something that would be rentable. There's a number of different reasons for that. Some of it is the location of it, the ability to put in any future ventilation. But then we looked at the sump, or there's a septic pump that bangs like crazy. You can't rent it out. So I think it's based on a false assumption that we have a secondary suite, and there was no inspection to confirm that. It's kind of difficult to prove something that doesn't exist, that it doesn't exist. So I'm not sure where to go with it. We do, on our website ad, we do state that there may be property manager on site. That's intentional to deter predators. So basically, and is essentially true. They don't stay overnight. The property manager does not stay overnight. It does not get downstairs. Does not eat downstairs. We ourselves have tried once to stay when a guest was there overnight. And again, it was the same thing. We stayed overnight, but we had to eat out. So there's no way that it's possible to have even two families in that place. It's just not a possibility. Throughout the whole of our operating, we've consulted with planning all the way along to make sure that we were following bylaws, we were doing what we were told to do. So all of this has been a bit of a surprise.
Okay, thank you. Does council have any questions of? Please go ahead, Councilor. Please, of staff.
Thank you. Just a question for our staff, in that I'm wondering, given that we're looking at compliance with zoning bylaw, 25 instead of 580. I'm wondering if staff could speak to capacity to have conducted any inspections of properties for business licensing purposes or anything like that within the time period that zoning bylaw 25 was in effect. Because, we have new regulations now, we have a new process that we're looking at now. In reading here, our staff do believe there to be a secondary suite for a reason. I'm just wondering if it was something that was under a previous inspection or something to that effect. Thank you.
I will say in a general sense, up until the business license amendment bylaws in October of last year, we really did not have a consistent, steady approach for oversight, implementation, enforcement of the short-term residential rental regulations, which were brought into zoning bylaw 25 in 2006. There was a period where upon structurally within here, our bylaw officers, planners and building officials weren't operating together to figure that out. That was the intent of the business license regulations from last year, to create and develop a program that we can oversee and roll out and implement. And so there are cases where business licenses were issued upon application without review and oversight.
Is any other comments?
Thank you, Chair. Maybe staff could explain what you take into account in determining that the unit is in fact a dwelling unit. What is required in notice reference to no cooking facilities is such a requirement for it to be a dwelling unit?
Yeah, certainly. I mean, the zoning bylaw has a definition of secondary suite and dwelling unit. There's no separate definition of cooking facilities, but it does generally run the gamut of, sort of a full kitchen with everything down to having cooktops, et cetera. In this particular case, the applicants had also submitted a temporary use permit application that they did not proceed with, but based on information included in that application, there was a marked up floor plan that we compared to the original building permit applications, where the basement under the old permit was an unfinished basement. There was storage and open areas, and the marked up floor plan showed the addition of a bedroom, bathroom, and a kitchen area. And that was sort of what we're looking at in terms of the information to say, okay, there was an unfinished basement previously, and this is the case with a number of examples where we can look at old building permit files and see areas where there were unfinished areas that were later converted into a suite later on. So that was sort of, in this case, what we're looking at, seeing from the original records to information that we have now.
So if I could just follow up on that, just to understand it. So the building records you have show an unfinished basement. And then in terms of the appellant's application, they're showing, is it a suite? Is it they are showing a suite?
Yeah, what's shown on the floor plans that were part of the temporary use permit application would form the basis for what we would call a secondary suite in terms of the definitions, talking about living areas, bathroom areas, cooking areas, all those different pieces, exterior exit, that kind of thing that would form a separate dwelling unit that would be considered a secondary suite.
And yeah, please.
So in the temporary use permit, the floor plan that we mapped out, we did put in summer kitchen question mark, because that was, as I said, we were exploring that potential. But this is not been done. There is a counter space with a wet bar. And there are no facilities in it, and there isn't the possibility to do this. There isn't the possibility to put. Again, I would welcome an inspection. I would welcome support if we can put in. It would make it much easier for us. It would have made it much easier for us through this whole process if we had been able to put in a suite, get somebody in there as a long-term mentor and run the B&B under the new zoning bylaws. That would have been our preference. It was not a possibility. So yeah, this is where we're at.
Thank you. Any, sorry.
Yes,
Auckland.
thank you through the chair. I'm just wondering for that lower quote suite, if now that might be considered a bed and breakfast, which is now part of the SDR, family of uses. It wasn't really, it was a home business in the old bylaw, and now it's considered part of our SDR program. So even though there may not be a full kitchen, there's enough to make food and perhaps use your outdoor barbecue for some stuff. I'm finding, that might be how it could be used. Possibly, perhaps that's how you would use it yourself if you were visiting. But the fact that it's there, you'd think it would be used for somebody somehow. So that's what I'd like to explore a little, please. Thank you.
And speak to that or to council.
Sorry, let us just gather some more comments from council, please.
Just asking because we're asking questions of the appellant proponent, I'll use that word. Based on the information you provided to us and the two pieces to the home that you've mentioned to us, could you see that home hosting members, two different groups, members of the same family?
Or two members of the same family.
Two groups of members of the same larger family, two groups of friends? Pardon?
Sort of, do you have it, whether it's family or not family, does it?
So two separate spaces. It's not possible. The issue is around the heat and the electrical. Heat is controlled upstairs on the main floor. You can't control the heat downstairs. Electrical is in the basement. So if a breaker goes, you need access. In terms of, I don't think there's a way to do it. I don't think there is a way to separate it. Yeah.
Thank you, Councilor Bell.
Through the chair. So just for clarification, I know there's a lot of information in here. So there has been nobody in the suite since you had a property manager in there on a full-time basis.
Yeah.
So that's what I'm
There's
hearing.
been nobody living in the house other than guest rentals. Yeah,
Okay.
because again, Bonnie's had the use of the whole house. He stayed in the basement, slept in the basement. And yeah.
And so that's essentially because there's no cooking facilities or anything in the basement. That was just to clarify that. Thank you.
Or Todd?
Thank you, Chair. And thank you for coming today. I've heard enough. I'm actually willing to move that legal non-conforming land use for 7471 Sechelt Inlet Road be approved due to clarification provided by the appellant.
And seconded by Councilor Bell. I'll put it to the vote. All in favor of that motion? All opposed? Carried. Thank you. 5231 Sunshine Coast Highway. Perhaps could I get the staff a quick summary? Thank you.
Sure. So in the case of 5231 Sunshine Coast Highway, this is an example where parking was the determining factor. So the short-term rental regulations under zoning bylaw 25, similar to how they are under bylaw 580, required one parking space per bedroom. So when we're looking, in comparison to looking at the residential use of the property that just establishes a number for a house or a number for a suite, regardless of the bedrooms, the short-term rental parking is one per bedroom. In this case, the 4-bedroom house would require 4 spaces. On this property, there's only 1 space available. There's a single car garage on the property, but the other 3 required spaces are not available on the property. So in this case, they have 1 out of 4 required spaces. Therefore, it's determined that this was not meeting the required parking at the time, so it could not be considered non-conforming.
Great. Thank you, Mr. Hall. Please.
Honorable council members, Mayor Henderson, thank you for
the opportunity to speak to you today. It's very meaningful for me, at least, to be able to talk to you folks about what's happening for us, and I'll keep it directed at the reason for the denial. The reason for the denial of our, my name's Sean DeVoe. My wife is Francesca DeVoe, and we run the property at 5231 Sunshine Coast Highway. The reason for the denial of our LNU status application was that our parking area does not meet the required setback under bylaw 25. I will demonstrate in a few moments why this setback does not apply in our case due to the unique topography of the property. We've been operating the short-term rental for the last 6 years. We've been issued a business license by the district every year, and we've paid our taxes and had no complaints. For the past 6 years, our parking area has served the spirit of the bylaw to ensure safe parking for our guests without infringing on any public parking areas or neighboring properties. According to the District of Sechelt, we've met all other requirements for LNU status, and parking remains the only issue. From planning, quote, "The parking area shown for your application is within the Ministry of Transportation highway right-of-way and therefore does not qualify as off-street parking. Many properties on our stretch of highway do not have the required setback as outlined in the parking bylaw because it's not reasonably possible to do so because of the topography of the property. The parking area backs onto a steep slope that leads down to the house, and it is not possible to build a parking area there. Due to the inability to reasonably comply with the bylaw, we requested some discretion be used by planning in our LNU status application. In the letter from planning denying our LNU status application, planning states the following. The district would provide a fair and reasonable review and evaluation of a TUP application, not LNU, for a type 3 STR where the off-street parking requirements in the zoning bylaw could not be met. This would be explained to council in a staff report with results in the evaluation matrix. An applicant must provide a detailed parking plan that can demonstrate how the STR parking will be managed within the public road right-of-way. This is in order to mitigate the negative effects of not meeting the parking requirements. The district is willing to consider this in light of the limited time frame of the TUP. In other words, planning would consider accepting our current parking situation if we applied for a TUP, but not otherwise. In my opinion, this is discriminatory and is a direct attempt to remove our lawful non-conforming use status. Council may not be aware, but by applying for a TUP, we would forgo our property use rights at the end of the TUP term. Our parking is no more adequate or compliant whether or not we choose the TUP or LNU status, but planning has told us they would apply discretion in one situation and not the other, and we feel that that's unfair. I think any reasonable person would look at this and consider those facts. My wife had a meeting with Ian Hall. She went to the office on March 27th and asked if there were any permits or variances on file for our property. Ian did a search and came back saying that there were none that applied to parking. On April 24th, I sent a Freedom of Information request to Sherry Taylor for our property. And on May 3rd, she sent us 2 documents, one of which was a 172-page document showing all permits that have been issued for our property. Near the end of this document, there's a scanned permit, which is in your package. It's a grainy image of a Ministry of Transportation zero setback variance permit for our property for the garage, not the parking area, from 1978. The implication here is that the ministry themselves recognized that setbacks for this property were not reasonably possible and so allowed for a zero setback variance. It is entirely possible that a zero setback variance for our parking area has been issued at some point, but we were also told that the records are a bit spotty that far back. We could not find anything. We are requesting that in light of all that we've done to be compliant, the council exercise some discretion that's already been told is possible and allow our application based on the reasonable arguments made above. The property does not allow for a reasonable setback. And I think if council looks at the picture of our parking area, it's actually quite wide. It's in your package and shows that there is reasonable parking on site. This isn't the fact that there is parking off site. The Ministry of Transportation Infrastructure issued a permit with a zero setback for the garage, implying the property is a problem, is a challenge. Planning would consider using discretion if we apply for a TUP, but not LNU. And lastly, I would just like to say that for us, I'm interested in hearing the feedback from council. I would like to understand the reasons for whatever decision you make, but this is not the end of the fight for us. That's all I have to say, and thank you.
Thanks very much, Mr. Devo. Wonder if there's police staff, any comment on that? Thank you.
Thank you, Mr. Chair. I think what we're trying to do in the letter is establish options. We do believe that lawful non-conforming use is objective. You meet the bylaw or you do not. A temporary use permit allows for an acknowledgement that lawful non-conforming status does not apply because the parking is on the road, not on the property, and allows discretion, fairness, reasonableness, and providing options. That's the different stream. Basically, one's objective, the other is subjective. So in our letter of denial, we provided options for the property owners to consider. We did the best we could in that regard. Thank you.
Okay, thank you. I'll just comment that I think this hearing is to make a decision based on what was permitted under the former bylaw. So that's what we're focused on. I'll put it out to council. Any comments? Councillor Toth.
Thank you. Yeah, being approved for a zero setback still requires the structure to be on private property. So if you've got a zero setback allowance for additional parking beyond the garage, it would still be on private property. Anything else would be an occupation of the road right of way, which when we went through the temporary use permit process, we approved a property that had zero on-site parking stalls. So we are willing to look at those options. But I think when we consider, a zero setback from the lot line, you can't have any parking between a garage that's at a zero lot line and the road allowance. So just my comments. Thanks.
Any other comment? Councillor McLaughlin.
Thank you through the chair. I'm also wondering if a TUP offers flexibility with future aspirations we have for the highway, whereas we can use the road right away for building paths for bicycles and pedestrians walking, et cetera, and if this parking might infringe upon that. Thank you.
Are you directing that staff question?
The intent with under the temporary use permit process where, in the case most recently in the last meeting was to offer council the option to approve a temporary use permit for a property that did not have sufficient parking. And the condition of approval was to provide for the applicant to provide a detailed parking plan to show how they're managing parking within the road right of way to reduce the impacts on public use of that road, knowing that even for an area right in front of a property, it's not exclusive use for the property owner. It's public road. Anyone could park there. So through that process for that particular property that was approved for a temporary use permit, they submitted a parking plan for our review. We've been back and forth with them on that and kind of working to resolve the final details, but they provided a plan showing three or more locations within the road right of way near the property where they could accommodate those spaces. Staff went out to investigate to verify that they were would be sufficient to meet the parking dimensions in the bylaw. And we've been working through that process, and that again, as part of the parking plan requirement for, this to form a part of the temporary use permit, to form a part of the eventual business license, so that the guests are informed of how parking is managed and, accommodating emergency vehicle access, garbage truck access, all these kinds of things that would be, within the lifespan of the TUP, ensuring that the parking is not impacting the public use of the area. And that was the case for this offer for this particular property. For any of these properties where parking was an issue, saying that within the temporary use permit framework, this wouldn't extinguish their non-conforming ability to seek non-conforming use in the future, but to offer now an ability to consider the situation within the 3-year time span of the temporary use permit, and manage that through that parking plan aspect.
Thank you. Oh, sorry.
Just two clarifications. One, I believe council has seen the picture of the parking area. Even though it is not set back the correct amount from the highway, it is not on the highway. It is not on the public road. I just want to make sure that's clear to everybody. And we have not infringed upon the road for any type of parking for us or our guests at any time. Number two, I'd just like to clarify a question for you, Mr. Hall, about, I believe you said we would not need to give up.
You could direct the question.
Sorry. Mr. Hall said that we would not have to give up our lawful non-conforming use status if we applied for a temporary use permit. That has been, that's incorrect according to council from our side. Once you apply for a temporary use permit and that expires, you no longer have lawful non-conforming use. So there is a removal of that right on our case, which is why we have been pushing back against it.
I guess I'll redirect that back to staff then, if there's that is staff's understanding of the TUP process.
Sure. It is our understanding through our own legal counsel that that is not the case, that an approval of a temporary use permit for a short-term rental for any of these operations would not extinguish their ability to seek non-conforming use at a later date. Hence our offer for all these properties to say, look, you can apply for a temporary use permit. We can resolve the non-conforming use at a later date, but the temporary use permit, if approved, would allow them to proceed this year and operate, assuming they get the 3-year permit. So that is something we did verify with our legal counsel, at least from our perspective, that this was the case, that this was still a legitimate option to offer people to allow them to move forward while allowing the non-conforming piece to be resolved at a different time. And one thing I just wanted to clarify too, I guess the parking regulations, there are required dimensions. I think it's 2.6 meters by 6 meters in terms of each parking space, but we don't get into setback requirements. So there would be setbacks for a building like a garage or house, but there's no required setback from a property line for a parking space. What we're looking for is there space on the property that meets the required dimensions in the bylaw. So in this particular example, and again, we're looking, within the property, is there space to fit parking spaces? So this is where the garage counts as one space, but there were no other spaces on the property that met those dimensions. And in terms of when we say no parking in the public road right of way, we're distinguishing the road right of way as the full width of the road, not greater than the paved surface. So that whether it's a ministry road or a public road, a district road, typically the road right of way could be 20 meters wide or more, sometimes less, but that's greater than the paved surface of the road. So that treating all of that as public land, whether it's owned by the district or owned by the province, that parking within that does not meet the off-street parking requirements. It's supposed to be within the private property boundaries.
Okay, thank you, Mr. Hall. Sorry, Councillor Bell.
think, through the chair, for clarification, I think you might have just answered this. So the new parking space that was built is not on your property. Is that correct? Yeah, sorry.
I mean, the existing
Director.
garage is on their property.
Yes, that is. And then there's a new parking spot that they have just built. Is that
No,
correct?
there's a parking area within the
Parking
ministry
area.
road right of way.
Right.
So
okay,
that there are several of these examples beyond this property along the highway where the STRs have been historically using space within the ministry road right of way. And when we're looking at that, this would not be the only case where we've determined that those spaces don't count towards the off-street parking space.
Okay, great. Thank you.
Thank you. Anyone else on council? So my understanding is that there is flexibility on the parking issue going through the TUP process. But again, the focus of this hearing is just on determining the legality of that parking under bylaw 25. So I wonder if does everyone have a good sense of the issue?
Chair, I wonder if I might just, because I've heard two different legal opinions, and when you've got two lawyers going black and white, I think I hear our staff saying the answer is yes, that legal non-conforming could be applied for. That's, you can be assured of that after the TUP.
Yes, it could be applied for and indicated at any time. The TUP is something that could be applied for and issued and is valid for 3 years. If nothing further ever happens and the TUP expires, then there is no claim. If one receives a TUP and continues to investigate and identify something that was not yet known to us and to you, the lawful non-conforming status could be appointed at any time. So there's a distinction there in how you view that. If the assumption is you apply for TUP and you no longer proceed asking for lawful non-conforming, then yes, you've got no status at the end of your TUP. But if you apply for the TUP because for some reason you need more time to identify and you're able to identify a building record or something, you can still say, oh, I found the information I'm looking for. You're now lawful non-conforming. But as I stated earlier, the lawful non-conforming doesn't allow for this wiggle room of spirit. It's yes or no. It's a really objective in that regard. That's the difference.
Please go ahead.
Mr. Hall also just made reference to the fact that there are properties up and down that stretch of highway that also do not meet the setback required or the parking requirements. And I'm wondering if the same thinking logic is being applied to everybody and not just to STR owners.
Okay, I'm going to then put this question to council. Does anyone have a motion to put forward?
Thank you.
Please.
When we look at the letter of the law, I just don't see 3 more parking spots on the property. So I'm going to move that legal non-conforming land use for 5231 Sunshine Coast Highway be denied due to the considerations provided by staff for the denial of legal non-conforming land use status indicated on the appeal hearing agenda.
Is there a seconder for the motion? So Rebel was second. A vote. Any other comments? And a vote on the issue? All in favor? All opposed? Motion's carried. Thank you.
Thank you, council.
Next appeal 5944 Skookumchuck Road. Mr. Hall, if you could summarize for us.
Okay, for 5944 Skookumchuck Road, in this case, the decision was based around both the presence of a secondary suite and lack of sufficient parking for the short-term rental use.
Thank you. Ms. Castro?
Hello, my name is Valeria Castro. I'm one of the owners of the 5944 Skookumchuck. Dear councils and members and mayor, good afternoon. And I'm going to read my letter, make sure that I am concise. Thank you for the opportunity to present an appeal for our non-conforming request. We have been a short-term rental operator for almost 7 years and have held 6 business licenses since 2017. The district denied our application for 2 reasons, as already presented. The first is not conforming with section 324. The district has taken the position that we have a secondary suite in the basement, which creates 2 dwelling units. This was a basis to deny our application. We do not have a suite in our home. Our home has 3 floors. The basement consists in an entertainment room with a wet bar, a table for play cards. We have a sink with a tap, and there is no stove. There is no plugs to put a stove. We have any other kind of appliances. Additional, there is a small sink. Sorry, there's no dishes. There's no glasses. There's like liquid, nothing. It's just a microwave, I will say, and a countertop. Also, the basement area is not self-contained. It is accessible through a stairway to the upper level with the door without a key. And in that, like the basement basically controls the has the control for the electrical panel and the internet. And upstairs has the control for the temperature, like you cannot live without each other, basically. It is intended and constructed as a part of the house and the recreational area of the home. Therefore, it was an error of our application to be denied for this basis because there is no secondary suite. I just want to add something is that maybe got confused in the past, but just so you know, in the past, we had rent just a portion of the home. We never rent in 2 different at the same time. This we have done because to prevent that we could have larger gatherings during the COVID-19 pandemic. And sometimes we do that just to avoid large gatherings. But we have not, like, there's no way that you can have both rented basically at the same time. I have talked with Mr. Ho about that. I explained to him that what's the situation. And I agree that maybe in the future, if we want to have that as a suite, we need to require a building permit and do all the changes necessary. And it is possible in the future if we want, but at the moment, it's not a suite. The second reason is regarding the parking. I just want to give, I'm sorry I could not send this before, and it's very handmade by me, but I just want to give an idea about the picture of our lot and where we can have the parking and what we're talking about. I'm really apologize to be like handmade. The second reason then of denies the part 11 of zoning bylaw, the district position set out in the denial letter that is, we don't have enough area for 6 parking spaces. That's why I'm providing the picture that you have demonstrated that all the parking options we have for accommodating 6 cars. In reality, we rarely have 6 cars in our STR. 95% of the time, we have like 3 cars or less. Even though like people don't come here, it's very expensive. It usually is families, like it's kids. They usually come like 5 people in 1 car. But anyways, we have 6 bedrooms. We need to have six parking spots. The picture that I provide, just so you know, it's scaled in a large and medium SUVs, just to have an idea the size of the cars, showing that all cars can be parked inside of our property. And just so you know, we also own the neighborhood lots beside our STR that can bring in, if we need more parking, basically we do have that space. It's important to note that despite our request for no conforming for 6 cars, we have modified our listing to 4 bedrooms, which corresponds to 4 cars. We also want to raise as a basis of appeal the district refusal to consider our subsequent application for no conforming use for fewer cars than 6. We're moving close to property next month, and I'm the property manager, and I really wish I'm going to be beside and to take care of our operation and following the district requirements. We believe that we should have been permitted to amend our application if necessary because of outright refusal was an unreasonable and prejudicial result given our history of compliance. In our years, we have been trying to work, we have been working following the bylaws. And I'm available for questions. Thank you.
Thank you very much, Ms. Castro. Are there any questions from council? Let me, if I could put a question to staff. Again, it comes down to the issue of the secondary suite and what evidence staff have for the secondary suite. Was there evidence of rentals or so forth? Thank you.
In this case, no, I mean, what we saw was, similar to some other examples where the whole house is being rented. There were cases where, as Ms. Castro noted, the upper 2 floors were being rented, and the basement level was not being included in that rent. But we did see references to where that was being kept for the owner's use for them to stay at different times. So no, it was not, the basement level, as far as we could tell, was not rented out as a separate unit, similar to some other examples. But from the information we had available, it looked like there was, all the pieces of a secondary suite were there. And then in terms of the parking, again, we're looking at, a 6-bedroom house, so 6 spaces. We could confirm through the information we have that, as you can see on the plan, there's a single car garage and there is enough space for 2 cars to park along the driveway. So you can get 3 in the garage and the driveway. However, we have a survey from the building file, not of the finished building, but of an earlier stage that showed the front area between the front property line and the building at an earlier stage of construction was already less than 6 meters for most of the building. So, we could determine that there would be space enough to meet the dimensions for 1 parking space in that front area, but not to accommodate 2 more cars without encroaching into the road right of way.
Thank you. But sorry, if I could just go back, what's the information that you used to determine that there was a secondary suite in the house?
We're looking again at the information we have through building permit records, as well as the short-term rental listings, Airbnb, VRBO, et cetera, and looking at pictures and trying to determine what we can from there.
Thank you. Councillor Bell.
Through the chair. So can you just review again the parking again? So based on what is at this point in time in this property, how many cars do you feel that they can park there?
We'd be satisfied that they could park 4.
Pardon me?
4.
4. Okay, thank you.
And just to clarify too, that where a property owner might own neighboring properties, the bylaw regulations don't allow parking on another property. So for the STR use, the whole parking for the STR use has to be accommodated on the subject property.
Thank you.
Councillor Toth.
Thank you. And just to clarify, those parking requirements are based on a 6-meter parking stall. So while it might be practical to park compact cars in front, it does not fit the actual dimensions of a parking space that we required under the previous bylaw. So, just a comment.
Can I?
Just go ahead.
Sorry. We're actually missing 6 centimeters. I'm sorry, yes, like we measure and we're missing, I didn't know. My lawyer said I should not bring this up, but I just feel, sorry, it's ridiculous. It's 6 centimeters that we're missing. It's why it's not compact, it's medium to large SUVs. If I have a truck, it fits actually, but if we put the 6 meters, we have 5.94. We have 5 meters, 94 centimeters.
Okay, thank
In
you.
that, in for 2 cars, the other 4, we are good.
Okay, thank you. Any other questions from council? Please.
Can I clarify? So this is, the application before us is for a 6-bedroom short-term rental or a 4-bedroom?
6-bedroom, I believe.
Would you change to 4? I'm okay, like I want to go with 4. It's just for family reasons.
Would you like to withdraw your application?
No, I'm
Okay.
6 and I have 6 spots.
All right, then it's a 6-room application, short-term rental. If there's no other comments from council, I'm going to move that the legal non-conforming land use for 5944 Skookumchuck Road be denied due to considerations provided by staff with respect to parking and the secondary suite of legal non-conforming land use status included on the appeal hearing agenda. For that. Councillor Inkster, seconded. All in favor? Councillor Toth, not in favor.
Actually, if you don't raise your hand, it's still a vote in favor. There's no such thing as abstaining or, yeah, you didn't, yeah, just wanted to clarify that. I just didn't raise my hand, that was all.
Thank you. Thank you, Ms. Castro. 7567 Sechelt Inlet Road. Anyone speaking to? Sorry.
Okay, Ms. Cox is now able to speak online.
Please, Mr. Hall, if you could give us a summary.
Hear us?
Okay, so for 7567 Sechelt Inlet Road, the determining factor here was the lack of parking. There's a 2-bedroom house proposed for the SDR operation, which would require 2 off-street parking spaces, and the property has no off-street parking spaces. And that was the basis for the denial of the non-conforming use application.
All right, thank you, Mr. Hall. Is the appellant, Mr. Cox, online? Yes.
Yeah, this is us here. You can hear us?
Yes.
Great. My name is Gary Birchall, and I'm here with my wife, Jennifer Cox. We are the owner of 7567 Sechelt Inlet Road out in Twanik. And as a side note, we live directly next door to that address. Thank you very much for your time and consideration on this important matter for us. And I apologize for having to do this through Zoom, but we were out of town. So firstly, a little bit of history on that cabin. It is that old one that Mr. Allen was speaking of earlier. It was built in 1967. It has 1 single detached dwelling on the property. And as far as we know, no changes beyond anything cosmetic have ever happened to it. It would never have had parking built for it. It was built, like I say, in 1967 before any zoning laws existed at all. So there's simply no off-street parking. But do note, right, there's never been a parking issue because the spot that it is on the side of the road is right in front of the door. It's not really a busy part of Tewanek, et cetera, et cetera. So just a little bit of history on the jurisdiction in case everyone doesn't know. 1967, Tewanek was part of the SCRD. And then in 1970, the SCRD adopted their first bylaw number 35. And with that bylaw came a requirement for off-street parking. And we were zoned as R1, which was residential use back then. At this point, I just wanted to bring up the two relevant sections of the Local Government Act, which probably everyone is aware of. Section 528 protects lawful non-conforming use, and Section 529 protects lawful non-conforming structures. So there is a significant difference between those two sections. So in 1970, when that first zoning bylaw came in with the SCRD, our cabin's use would have been residential at that point in time. But the structure was not conforming because it now required parking. So at that point in time, the parking became legally non-conforming. Then in 1986, Tewanek was annexed to the district of Sechelt, I believe. And then, of course, in 1987, the last bylaw was adopted, number 25. And then in 2006, as has been discussed, the new short-term rental use was added to those bylaws. At that point in time, our cabin remained residential. It's not a short-term rental at that point in time. Then in 2019, we submitted an application to change the use to be a short-term rental, to which the district issued us a business license. So again, in 2019, short-term rental was a permitted use, and our cabin had legally non-conforming parking due to the protection of Section 529. And I would say that the district apparently recognized both those pieces of information and therefore issued us our business license. Then in 2022, a new set of bylaws adopted. Short-term rental was removed as a permitted use. However, thanks to Section 528 of the Local Government Act, we have legal non-conforming use, we feel, as well as we have legal non-conforming parking under Section 529 dating back to 1970. So, in conclusion, district staff have interpreted Section 528 and Section 529 in such a way that the use of our property now must remain residential due to the parking. We've been advised that that's not how the legislation works, as we have hopefully demonstrated here. So the two questions council needs to consider today. As of October 7th, 2022, when the new bylaw was adopted, was our cabin's parking protected by Section 529 from back in 1970? And number two, was our cabin being used legally as a short-term rental? And if so, our cabin must now be recognized as having a legal non-conforming use, as well as legal non-conforming status under 529. And if anyone is still in doubt at that point, given that the last use of the property was a short-term rental, how then are we able to change its use back to being residential, given that the same parking restriction exists for both uses? And that is all I have to say.
Okay, thanks very much, Mr. Pachal. We'll open it up to comments from council.
Oh, I'll start. Me.
Go ahead, Mayor.
Through you to staff, I'd actually be curious for an answer to the second question, the last question. If it's not legal as a short, if there's not enough parking for short-term rental, there's no parking. Yes, is what happens in this case? Yeah, that's outside the realm of today's. Oh, I think I'd like staff to answer if you could.
A brain twister, undoubtedly. So to review the facts, the property was built in, the structure was built in 1967 and without parking. And then in 1987, a zoning bylaw applicable for this area within the district of Sechelt applied, requires parking for a house. The house exists and therefore section 528 and 529B do apply. In 2006, short-term residential rental became a permitted use. Along with it came the requirement for a parking space. We issued business license in 2019 without review or presumably formal acknowledgement of lawful non-conforming use. And that's what put us in this pickle in terms of this review here. And that's why we made our recommendation. In terms of what happens to the house, there's no provision to say one cannot use the house. If the house perhaps were to be added onto or expanded or a suite added in, then we would say parking is required. At that time, it could either be rejected or we could say you require a development variance permit to authorize the non-parking. But we just didn't know how to connect the dot to say non-conforming when short-term residential rental was not introduced until 2006, along with it coming a requirement for parking. So that's the basis for our interpretation of this one. Thank you.
Me too.
Is there any other comment to that? Councilor Toth.
Thank you. I guess I've just got a question for the appellant, because you've got one parking space in front of the property essentially right now. Do you have a contingency plan in case you lose that parking space? Whether we needed to widen the highway to Tawanik, or whether BC Hydro puts a pole in the middle of it. I just wonder if you've got a contingency plan in case you lose the one parking spot you do have out on the street.
I might suggest right now we have room for 2 cars right in front of our cabin. However, I don't know. I guess we would cross that bridge when we get to it. There is a lot of room in our area of Tawanik to park. And if all else fails, I guess we could investigate potentially putting in a parking space, but it would be very, very difficult. It's a very steep property. It would likely cost 6 figures to happen. So, and if I may, I'm changing the subject again, but I just want to point out again that back in 1970, I firmly believe that we had achieved legal nonconformance for our parking long before the concept of short-term rental ever even existed. So I just want to keep that bug in everyone's ear, because I think that's the fundamental argument here.
All right, thank you. Councilor Bell.
To the chair, I'm not sure if there's any more discussion, but I'm ready to make a motion. There's no more discussion.
Yeah, please.
I motion for approval of legal non-conforming land use for 7567 Sechelt Inlet Road.
Councilor Toth. All in favor? All opposed? Sorry, the motion is carried. Thank you very much, Mr. Burchell. I will move on to 7634 Sechelt Inlet Road. Mr. Hall.
Thank you, Council. So for this property at 7634 Sechelt Inlet Road, we had determined initially that there was a secondary suite on the property, and that was the basis for our first decision letter. Subsequent to that, the applicant submitted additional information and in a sworn affidavit, and we were prepared to revisit that decision. But as part of that, we continued the review to make sure that the parking was not going to be an issue, and it turned out that the parking was an issue. So while we were prepared to revisit the secondary suite issue on this property, we determined that the parking regulations were not being met. And therefore, the second letter decision was made to deny the non-conforming use based on a lack of parking.
All right, thank you, Mr. Hall. Is there an appellant?
Yes, the appellant has provided a recorded statement, which we will display on screen here, and it will be visible over YouTube as well.
Thank you.
I'm wondering, corporate officer, whether we could just stop the recording. Because we're far off the subject.
Thank you. If I could may just raise a point of information. The audio was not actually playing on the YouTube feed, so we will have to post this video after the meeting so that the public does have access to that.
Great. We'll go to council for any questions. The recording. Councillor Toth.
Thank you. There feels like a little bit of discrepancy in between page 165. That shows the parking inside on the property line, but they mentioned that the emergency evac area is in front of the gate, which to me looks like the parking is inside the fence. And then page 175, the drawing clearly shows the parking outside the fence. So I'm looking for a little clarity in terms of where the property line is in relation to the fence from staff's perspective, I suppose, since the opponent's not here to give a little more clarity.
Thank you. In reviewing this property, staff looked both at sort of the old air photos, over time, there's an old, Google Street image as well as visiting the property more recently. There certainly has been changes made to the property over time where previously, we could see in old data where there was a larger vehicle, like a rolling gate on the property that would have and graveled area where parked cars could have made it through the gate and parked on the property. That goes back 10, 15 years based on the street view data. But the property currently and at some point in between then and now has been entirely landscaped within the fence, even though the fence may have been relocated and changed. It's no longer having a sufficiently wide enough gate for vehicles to access into the property, and there would be no, I guess you could say that there's theoretically space, but it's all been landscaped. There's no parking area available like there was previously. So the fence line, while it may not be exactly on the property line, there's staff are confident that there's not enough space to meet the dimensions on the property between the fence and the road. In this case, the road right of way extends obviously beyond the paved surface. So where they've proposed parking outside of the fence is within the public road right of way, similar to other properties in that area, but there's definitely no insufficient space between the fence and the property line to actually park cars on their property.
Thank you. Does anyone else have questions on parking with this file? One want to raise a motion? Okay.
Yes, so a motion to deny a legal non-conforming land use for 7634 Sechelt Inlet.
Seconders. Councillor McLaughlin. Call the vote. Any other discussion?
I think I'm going to support the motion, but I'm concerned that there's two points. I'm supporting it on the basis of parking, but I have real concerns about, that we seem to see a theme here of secondary suites that are or aren't, and I'd sure like to see that, let's tighten that process up going forward.
You're in support of motion. So I will call the vote. All in favor? All opposed? Carried. Thank you. We'll move on to the next file, 5851 Skookumchuck Road. Mr. Hall, do you want to give us a summary, please?
Thank you. So for 5851 Skookumchuck Road, the decision to deny the non-conforming use application was based on what staff determined to be the presence of a secondary suite. And that was the the issue at hand.
Thank you. Mr. Deng,
Yes,
please.
okay. Good afternoon, everyone. Thank you for having me on board, allowing me to explain the situation here. Yeah. We have held a short-term rental business license for 4 years now. We love this beautiful Sunshine Coast and would love to host our guests to it. We believe this house is suitable for non-conforming uses because there's no secondary suite. We have never rented out this house to any long-term tenants or situations. We have always been rented this entire house as one whole unit to the short-term rental. And there's a few things I like to point out that the basement is currently not a secondary suite is because there's a dryer, there's laundry in the secondary suite, in the basement that we only have one. So if we need to rent out the main floor, so guests need to come down to use the laundries. So there's no way we can do that. Also, there's no kitchen. Kitchen's in the main floor. Right? The thermostat is controlled in the main floor as well. I have spoke to Mr. Ian Hall. If we can set up an inspection to have a look at the house to identify, to make sure, so we can move on with it. The situation is, we love the Sunshine Coast so much. I was, building other houses here before, and I said, hey, this is so nice. This is gonna, me and my wife have decided to move over here after my daughter finished their kindergarten in about 2.5 years. There's no way we can rent this entire house out as long term for the next 2 years. There's long term, you cannot get it back when you want it back, in a certain way. And in the meanwhile, we do want to keep kind of coming to the Sunshine Coast for visit. So it's not an ideal situation for us. Right? So this is like why we would like to continue to use the non-conforming usage of this one.
Thank you, Mr. Deng. Does council have any questions of Mr. Deng or of staff? Thank you.
Chair, how do you access the basement, Mr. Deng?
There's one access down from the main floor to the basement. And
There must be a door on the ground.
in
on the
between,
basement.
that's right, yes. But
No, sorry, but is there not a door to the outside?
there's a door outside as well, yeah, to go out to the front yard from the basement, yeah, right.
Okay, but there's no kitchen or
No,
stove or
no.
exhaust fan?
There is a wet bar. There's a wet bar. Yeah, it's a wet bar. That's about it. Thank you. That was same.
I wonder if I could direct a question to Mr. Hall. So again, the evidence that staff accumulated to determine that there's a secondary suite.
Sure. Given this house was constructed more recently, we have a relatively recent building permit files. So we can see from the original building permit that the basement area was an unfinished basement. I think it was storage, rec room, that kind of thing. And based on review of the applicant's information from the temporary use permit, the non-conforming use application, and looking at the short-term rental listings and the photos, we could see that the basement had been converted. There was now a bedroom there, and we could see in the sort of the opposite side kitchen area. There was also a reference in some of the listings that the guests, like the basement area was never rented out as a separate unit. It was the whole house was rented out, but you know, based on the pictures and everything, and then also there was a reference in some of the listings from the owner that the guests were not to use the kitchen in the lower basement unit. So between the photos and that kind of looked to, so here we have an unfinished basement area that was converted. And from the information that we have available, it forms all the different pieces of the secondary suite in terms of access, cooking and living facilities, but that's the information that we have.
Yeah, thank you. I wonder if I could ask Mr. Dang, and you haven't been living at the premises either. That's not your principal residence.
It's not my principal residence, but we do use it occasionally in the summertime, a little bit more often. Like to just reply to Mr. Ian Hall, some of his comments. Yes, there is a storage that my wife put into the Airbnb, say don't use. It's our own you know, food and that our own items. There's only a wet bar in the basement there. So and I believe my wife probably mistakenly put it kitchen because it's concerned about wet bar. So anyway.
Thank you. This comes down to an interpretation of what other. Sorry, Councillor Todd.
Thank you. I'm going to move one of the options here in just a moment. I just wanted to highlight something in the parking plan that was presented to us. Recognizing that the driveway is far large enough to support all the cars. Three parking spots are identified out in the road allowance. So I just want to discourage the appellant from advertising the street as parking area when it's not. But I am willing to move that legal non-conforming land use for 5851 Skookumchuck Road be approved due to clarification provided by the appellant.
Is there a seconder for the motion? I'll second. I will call the vote. All in favor? 3, all opposed. Defeated. The motion's defeated. Thank you. And there are no more appeals, so I will call this meeting to adjournment. Thank you.